Social justice means applying the law equally to all people. But in practice, that doesn't always happen. I'm John Gonzalez. I'm here with my law partner, Jack DeRora. We practice law. We seek social justice. On this show, we reveal the conflict between the two.
You know, for a while, it was just us in the office over a cup of coffee talking about the news of the day. With social justice issues dominating our culture, our focus became, how do we as lawyers make a difference?
And now it's not just us. Today we have attorney Charlie Weiss here to talk about wrongful convictions, how prevalent they are in our judicial system, and how difficult they are to overturn. Welcome, Charlie.
Thank you.
You forgot to mention, he's a Notre Dame grad. Hey, before we get started, I saw something startling. At least I thought it was startling in the news. Did you read about the Florida Supreme Court?
I did, yes.
So the Florida Supreme Court writes a letter to the director of the Florida Bar Association and says, you know, we don't like this idea of the Florida Bar Association sending delegates to the American Bar Association, short ABA, because, you know, they're involved in these rather controversial things, and those controversial subjects, that's separate and apart from what the Florida Bar Association should be doing. So we're going to ask you not to send delegates, change your rules, but we don't think you should be part of the ABA, which is really interesting because the Supreme Court is telling the Florida bar lawyers basically how to conduct themselves. So I looked and I saw that the Florida Bar Association is, in some respect, an arm of the Florida Supreme Court, which I don't think is similar to how we're situated here in Ohio. But still, it's stunning that the Florida Supreme Court is basically telling Florida lawyers how to conduct themselves. So let's go a step further. So then, wait a minute, there's more. There's more. Who's the Chief Justice of the Florida Supreme Court but a gent named Carlos Muntz, or Munitz? I'm probably getting that wrong.
I'm sure it's a coincidence that the Chief Justice of the Florida Supreme Court was once in the Trump administration.
Oh, you read the same article. Yeah, mere coincidence. And then here's what's also interesting. I think it was just yesterday or the day before, the ABA filed suit against the Trump administration for its heavy-handed approach with executive orders against a number of large law firms.
What strikes me in general about this is that conservatives, and certainly the Chief Justice is a conservative, seem to be on a control mission these days. Not only controlling actions, but also, thoughts and opinions. And you and I both know that couldn't happen in Ohio because our State Bar Association is an independent organization. So it can do as it pleases. If we don't like it as lawyers, we don't have to be a part of it. But yeah, it strikes me as odd. I haven't spoken to my brother, who's also a Notre Dame grad, about how he feels about it, but he is a big Donald Trump supporter, and I suspect he's going to be just fine with it.
Probably. But I just thought it was worth talking about.
Oh, my. So to the topic at hand, you and I have spoken about my post-conviction case that I took to the Ohio Supreme Court, Mr. Hatton. Charlie, Mr. Hatton was convicted of rape and sentenced to 39 years in prison, and found after about 18 years some information that suggested that the DNA that was used in his trial was not accurate, and that actually the expert had walked back what some of her testimony would have been in a memo to the prosecutor. It took us a couple of years to get his case through the system of being denied a new trial until the Supreme Court said, yeah, he should get a new trial, go back to the trial court. I was telling Jack the other day, I think this first time I had ever described this to you, we went into the trial court for the first hearing with our client present, and there was a courtroom full of people. Other than the paralegal and me, none of them were in support of what we were doing. And, the phrase, if looks could kill, kind of came to mind, because not only did they not like my client in this little town in Ohio where he was convicted, they didn't care much for the lawyer that has, to that point, been very successful in getting a new trial. And doing civil work for most of my profession, it was a little bit of a shock to me to be that hated for the moment.
Oh, I'm sure it was. I can't imagine. I've had a slightly similar experience, Charlie. I'm with a prison ministry, and I was attending a parole hearing for one of our men, and most of our men are in for 20 plus. So that means, for the most part, they've murdered somebody. And this fellow had murdered somebody, but like all the men in our program, he had turned around, he was serious, he took responsibility, et cetera, et cetera. So he's before the parole board. We have a couple of our people speak on his behalf, and the family of the victim is there. Now, this is north of 20 years, and all they can do is talk about the harm that they've suffered. Well, of course, who can dismiss the agony that they faced, right? We get that. But I remember feeling really bad for those people, because I thought, wow, they haven't accepted this terrible reality, and they're stuck. They're almost in a worse place than our man who's up for parole is.
Charlie, I have to imagine you've had a similar experience. You've been doing this work a lot longer than Jack and I, and many more. But when you do work on these post-conviction cases, have you had to deal with the families or with law enforcement that just see you as the enemy?
We have been very fortunate in, I have not experienced what you experienced, where we had a hearing and there were a lot of people in the courtroom that opposed what we were doing. Most of my cases, we've been very supportive. And in fact, in almost all the cases, the family of the person that we represent have been supportive and been in the courtroom and supported what we were doing.
Oh, that's got to be a big help.
It is a big help, absolutely. The first case we had, the actual sheriff, the new sheriff of the county in which the person was convicted, was supporting us and was a primary witness in our case. He believed that the conviction initially was wrong and that they had the wrong person in jail. And so that's the kind of support that we've had in the 5 cases that I've been involved in where we were able to vacate the conviction.
I have a good friend of mine that was the mayor of a small town where this occurred by, and he was in law enforcement for years, so he knew the detectives on the case, and one of them had been on the case and was still around, because we're talking 25 years later. And after that hearing, the detective had told my friend, who then told me, he said, I'm doing everything I can to keep this guy in jail, but I don't want to go through cross-examination again, which I took as a compliment, right? But so far, Marty, unfortunately, is still in jail because now it's up on appeal. But you work for a firm that I would say is more of a civil firm. How did you get involved representing convicted criminals?
Sure. So when I joined our firm in St. Louis, our firm is 151 years old, by the way, probably the oldest continuing firm west of the Mississippi. There were 30 lawyers in the office when I joined, one office in St. Louis. I did not interview at Bryan Cave, the firm, because I wanted to practice trial lawyer, and they had the reputation, as you say, John, of a civil firm that did civil work, and I didn't want to spend all my time in the library. I wanted to be in court. But the judge that I was clerking for, the Court of Appeals, the 8th Circuit Court of Appeals, called me and said, hey, Charlie, you haven't come down to Bryan Cave to interview. Why not? I told him that. I said, Judge, I want to be trial work. I do not want to spend my life in a library, and that's what I perceive if I joined Brian Cave. He said, go down and talk to him, would you? So I did. I interviewed him, and I got an entirely different perception of the firm than I had thought was how the firm operated. So when I joined Brian Cave, we had no public defender system in Missouri. An indigent defendant was appointed from the civil roles of the bar, whether the lawyer had criminal experience or not.
Oh my.
When I joined the firm, I went around to all the partners and said, if you get an appointment, I will handle it for you. So the first 2 years I was here, I tried 8 civil felony cases to a jury as appointed public defender. That's how I got involved in the criminal, not a criminal lawyer. And so then several years later, I got an appointment of a person who had been convicted of bringing 4 of his friends home and raping his wife. He'd been sentenced to life imprisonment. Anyway, we appealed that all the way to the U.S. Supreme Court, and the U.S. Supreme Court reversed it in a unanimous ruling. And then most recently, I'm a member of the American College of Trial Lawyers. The president of the Missouri chapter called me and said he had gotten a referral of a case who they believed was innocent, and they wanted somebody to handle it. They could not give it to a small firm because they thought it would take too much work. Would I take it on? And I said, I'd only take it on if I am absolutely convinced that the person is innocent. And so I did my homework, talked to the people. I visited the person in prison. I was convinced he was innocent. That was our first case. And he was vindicated in 2009. That was the first innocent case I had where a person who'd been convicted and sentenced to life imprisonment was vacated. Fortunately, we had a judge who had been a career prosecutor. He understood how things work under the criminal law. He got interested in the case. He heard the case and wrote a 52-page opinion, a great opinion, explaining why this person was innocent and how things went wrong in the initial conviction. His name was Rich Callahan, graduate, and he was also subsequently a U.S. attorney here in St. Louis.
One of the things that I noticed doing this, what I call post-conviction work, because I've had a lot of civil jury trials. I stay away from criminal jury trials. So almost all my work, Charlie, is post-conviction. And then if we're successful in it, either withdrawing a plea or getting a new trial, I turn it back over to the attorneys that do that boots on the ground work. But the resources are so vastly different, especially if your client's been in jail for 20 years. Usually the families have exhausted all of their money to help that person. And it struck me as what you said when the judge called you and said, well, there's a firm that's too small to handle it because, I don't have the resources and we're a small firm. Did it help you to be in a larger firm? And then, I know that some of your cases were co-counseled by the Innocence Project people. That must help too as far as resources. Yes,
we have worked with both the Innocence Project in New York, Barry Scheck's firm, and the Midwest Innocence Project, which is based in Kansas City. And that's a big help. But yes, absolutely, it's very helpful to be with a large law firm and our firm is very good about supporting pro bono efforts. And so they will give me about anything I need, including taking depositions, doing DNA testing, whatever it might be. And that's very, very helpful. And I also have the support of associates and partners who are helpful also. The one thing I think we all realize, John, when you take these cases, they don't happen overnight. You have to have perseverance. Most of them take years from the time the initial habeas is filed with the trial court to the time it gets up to the appellate court that ultimately then will decide the case. 2, 3 or 4 or 5 years sometimes it takes. And you're not getting paid if you're doing it pro bono, but is there ever a case, or have you had the case where after you've prevailed, you're able to take the civil case and get compensation for your client? In all the cases so far, we've got one pending right now, but all the cases we have so far, we have done just that. We have been able to file a 1983 case to obtain some money for the person, because that person has been in jail for 15, 20, 25, 28 years, gets out, they have nothing. And so we've been able to do that and help them back on their feet, and all of them have done well since they've been out of prison. The one case I had, Josh Keyser, which was the first case, as we were speaking on the podcast, I noticed he just called on the phone. He speaks to me almost daily. And that's the one who got out in 2009, and he's now very much involved in innocence cases.
Well, I'm glad to hear that. That's a man who shows gratitude. Hey, Charlie, one of the things that I detect, at least, well, this is hardly a profound statement. There is a real reluctance on the part of the system to go back and reevaluate.
Yeah.
It's as if the system is saying, we've been there, we've done that, we must have gotten it right, go away, you bother me. Tell me about if that resonates with you, if that's your impression.
Yes, it is. That's the finality rule. So, one of the rules we have in a litigation is after you've been convicted or a judgment against you and you go through the appellate process, it's a final, and we want things to be final. However, the system is good enough and flexible enough that wrongs can be righted, even though there's a final decision. And that's what these habeas cases that you work on are all about. We have rules in our system that allows innocent people to be released if there is clear and compelling evidence that they're innocent.
Well, if we go back to the ability to have the resources to fight the state, because my experience is these prosecutors don't give up those cases very easily. And of course, the trial judge who sat over the trial and the conviction, they're not apt to say that they made a mistake and that they're willing to do it. So it almost always takes an appellate court or our Supreme Court to really come down hard and say, hey, you take another look at it. But that tells me that there are a lot of wrongful convictions, or at least issues with convictions, that aren't being looked at or addressed by lawyers at all. Do you have any fill or actually statistics? How many wrongful convictions are we looking at? Is there a certain percentage of cases that we can say were maybe, wrongfully decided?
John, I've seen statistics anywhere from 2 to, I don't know how scientific the estimate is, anywhere from 2 to 5% of the people in prison are actually innocent of the crime for which they were convicted. It's interesting, your comment about prosecutors do not like to see their cases reversed. So I've been doing this now since 2005, 2006, almost 20 years. And most of the cases that we have are opposed by the Missouri Attorney General's office. They have a rule that they oppose every habeas case brought, regardless of what the evidence is. They just automatically oppose it. The first case we had, the Keyser case, we went and sat down with them because I knew some of the people in the office. I went to Jefferson City, sat down with the person. We spent 2 hours, laid everything out in the desk, all the evidence, the depositions we had and so forth. And at the end, she said, Charlie, she says, I appreciate what you're doing. I appreciate you coming up and talking with us. But our policy here is to oppose all of these. So do what you have to do, file what you have to file, but we will oppose it. And that's been the case since that time in 2006. Every case we've had has been the same. They oppose every case.
That's an interesting policy, Charlie.
Yeah.
Policy is, I'd like to think, generally based on some rational thought process.
Yes.
But isn't, like the policy here, is it just ego-driven? What's your thought?
I think it's political. I think it's political. Missouri is a very conservative state, a law and order state, and so most of our attorney generals have, even though there have been several Democrats, in addition to the Republican attorney generals, they all do the same thing. They just automatically oppose it. I think more. My view is it's political.
I want to go back to the statistic you cited. I think you said 2 to 5% of those incarcerated were wrongly convicted. Let me add to that in a way. In Ohio, we have 6 men who were released from death row, not on legal technicalities like wrong jury rules, evidentiary problem. They were found to have not been the guilty party. That's on death row. That's a staggering thought. They were exonerated.
It is.
And it wasn't by agreement.
Yeah, and it wasn't by agreement, right?
Because back to our thought about, the prosecutor. So in Ohio, Columbus leans liberal. Big city in Ohio, and we have a Democrat elected as the prosecuting attorney. And that office actually will look at convictions if you bring it to them, and they have a little division that will look at it. And I'm not sure how successful it is because it's never in a prosecutor's best interest to be too light on crime. But then we have these smaller counties, especially in southern Ohio, where they are as conservative as anywhere in the country. And those prosecutors know where their bread and butter is. And in the little county I was in with Mr. Hatton, I could tell by the packed courtroom that prosecutor wasn't giving up without a fight because she wanted to be elected again. In fact, she was going to run for the county judge slot. She ended up not getting that, but was still the prosecutor. So, I agree with Charlie. I think it's politics, and I don't know if you can keep that out of that. That I don't know if maybe having some type of an independent review board, which gets me to a question, Charlie, that kind of goes with my thought here.
Yeah.
How do you pick your cases? Because you can't take everyone. I'm sure you have to be somewhat choosy.
So let me first talk about the prosecutor in politics. So we have an attorney general's office which oversees all of Missouri, but all of our counties and major cities have elected prosecutors. 4 or 5 years ago now, a number of local prosecutors around the state instituted what they call conviction review units, where they would look at a case that might be questionable. And in St. Louis, the prosecutor is Democratic, and she found a case that she thought the person was wrongfully convicted, and she filed a motion. She, the prosecutor, filed a motion for a new trial to have a new trial for that. Ultimately, the attorney general came in and opposed it, went up to the Missouri Supreme Court, and they affirmed, saying a motion for a new trial has to be brought within 30 days of the final judgment. Here we're 20 years later. You can't do it. And one of the Supreme Court judges wrote a decision, and he said this should be solved by legislature. So several of us got together and wrote a statute, which the Missouri legislature passed and became effective in August of 2021. And it provided that any local prosecutor in the state of Missouri who had clear and convincing evidence or information that the person was innocent or may have been wrongfully convicted because of a constitutional violation can bring a suit to vacate the conviction. That was passed, and now we've got, I think, 3 or 4 cases where that statute has been used and the person has been vindicated. So there's a politics, even though
I like it.
Only prosecutors can do that. The individual, it didn't apply to an individual, but if a prosecutor finds clear and convincing evidence or has clear and convincing evidence, he or she then can bring a suit to vacate the conviction. And we've had 3 or 4 cases now since that time where the prosecutor has done that and has reversed conviction.
Are you saying in the great state of Missouri that if the prosecutor doesn't bring that action and the criminal himself brings it, he's barred by the 30-day rule?
I am, Jack. In fact, we have now, in the past 2 legislative sessions, the legislative session in Missouri ends at the end of May, we have had an innocence statute brought just to do that, saying, prosecutors can do it. Why can't an individual bring his own case if he has clear and convincing evidence of innocence. I think it will get passed. I do think it will get passed, but for 2 sessions, it was not. We didn't get it through.
The politics is interesting. It was 6 or 7 months ago. I'm going to ask you gents to help me. It was a case in Oklahoma, and it was the attorney general fighting for the new trial, and the governor and other forces were opposing it. And I think it went to the Supreme Court, but it although I'm fuzzy with the facts, it was certainly speaking to the politics that you're speaking to, Charlie. It's as if, well, we just don't like thinking that we get it wrong. We don't like the thought of releasing somebody. There are a lot of bugaboos that guide our thinking.
Yeah, I mean, you can't take politics out of things. It's always going to be there. But fortunately, our system is big enough. There are enough good lawyers and good judges involved in it, whereby if we get lucky enough, a person who's been wrongfully convicted can be vindicated. That's not a perfect system. I wish it were better, and I wish we had a better way to make sure innocent people weren't convicted. They'll always be that way. It's run by human beings. We all make mistakes. There are errors made, and it will be the case. So there'll always be innocent people in prison, unfortunately.
For the benefit of younger civil lawyers who may be listening, who may think, gee, I'd like to help, but criminal law, what do I know about that? What would you say to those younger civil law attorneys who want to get involved but think they don't have the skill set to do it?
I would say, please do get involved. It's some of the best training and experience you're going to have. You're going to be working with experienced attorneys. We're going to be dealing with complex motions. You'll be in front of a judge, generally, not juries, but judges decide these cases. It's just great experience. It's some of the best experience you can have. And fortunately in our firm, we have a lot of young associates who want to get involved and are available to help.
So a young attorney could call the Innocence Project in Cincinnati and say, hey, how can I lend a hand?
Yes, I think they can do that, or wherever they might be. The other one we work with, the Northwestern Innocence Project in Chicago, Innocence Project in Kansas City, and Barry Scheck's New York Innocence Project. They're all very helpful.
Wait a minute, Barry Scheck, that name is familiar. That's the lawyer isn't that the lawyer from the OJ trial?
It is, the Barry Scheck, yes. And he and one of his partners formed the New York Innocence Project, and it's probably the largest innocence project in the country now.
Well, we were, talking about good people in the, in our profession, and that helps with these cases. If you can get somebody to look at it with a unbiased, mindset. But here in Ohio, before the Supreme Court got reconfigured more conservatively, they actually did a task force to look at wrongful convictions, and it was fortunate for my client, Mr. Hatton, because the task force it was kind of a hot ticket item, and the Supreme Court, the way it was configured, was very interested in it. So we leaned heavily on a lot of what the task force found to get jurisdiction for the Supreme Court to take the case. But one of the things that the task force identified were all of the procedural hurdles that have nothing with the substance or the merits of these issues. It's just procedural. And I imagine your state's similar to ours, where you have these time frames, and the only way to get outside them is to find newly discovered evidence. So evidence that wasn't around back in the day, or if it was around, you should have found it. And then that evidence has to make a difference. But then you couple that with what these courts were required to do, which was to use their discretion. So you go up to the Court of Appeals and say, hey, the judge got it wrong. And they'd say, it's discretionary. And, those are some tough procedures to beat, no matter what the merits of your case are. I don't know if it's similar in what you're doing, Charlie.
John, it's very similar. We face all those hurdles all the time. And I think three of the 5 cases we've had that we lost at the trial level where we file a habeas corpus. A habeas corpus in Missouri, I guess most states have to be filed in the county where the person has been incarcerated. And 3 of those cases went all the way to the Missouri Supreme Court, who then granted a preliminary writ of habeas and appointed a special master to hear the evidence. And those are the cases we won.
Mm-hmm. Well, I'd asked you earlier, and I'm not sure that you got to it. So how do you decide which case you're going to take? Which do you have a set criteria, or is it more of a gut feeling?
Good question, and not an easy answer. I've got a stack of papers on my desk from people who hear what we did and want to claim they're innocent. I have to be absolutely convinced in every case I've taken. I always first actually talk to the person that claims they're innocent. Usually it's a referral from someone I know or from one of the Innocence Projects. But I have to do I always do preliminary work to make sure that, as I said, these cases take too long and there's too much effort and sweat and expense involved in them. So you got to be pretty sure when you take these cases that the person is actually innocent and you can be able to prove it. So I do my homework, I guess, initially to make sure I understand the person. And usually it's someone that I know or I respect that referred the case to us.
Charlie, my experience with inmates, and admittedly somewhat limited, is that inmates don't lie about not having done it. My sense is they either don't want to talk about what happened, or the very few who are innocent will talk about it. What's your experience, or do you have any experience in that regard?
I think that's the same experience I have, Jack. When you start talking to somebody, well, I might have done it, but there's a technical issue. I should be,
Yeah.
Those cases I shove aside very quickly. But the person who cries that they've been there for 28 years and respected in the prison, that they've not been any problem in the prison. They've been through all of their classwork and respected by in one case we had, I've talked to some of the guards, and they were so convinced that this person was innocent, and he was. But that's kind of what I look for. That actually talk to some of the guards if we can. Is what do you think about this person? And a lot of them will just tell you.
Mm-hmm.
Oh, that's an interesting perspective. Talk to the correctional officers.
The inmates sometimes form a very nice bond. I mean, it doesn't surprise us, right? I mean, they're there with them day in and day out, and they get to know each other. But when we do motions for judicial release so they can get out early, almost always you can get one of the guards or one of the supervisors of the guards to write something to the judge saying, yeah, this guy deserves it. And to me, that's gold.
Oh, gosh.
Yeah, I mean,
can't imagine.
Right. So I have a little bit maybe less of a bar than what you're describing, Charlie. I know that for the most part, my clients want me to believe they're innocent because I get asked that all the time. What do you think, John? I didn't do it. You believe me, right? And I usually, and maybe I need to temper this the more I think about it, I usually say what I'm looking at is whether you got a fair trial. Because whether I believe you're innocent or not doesn't make any difference to the judge or the prosecutor. I think talking to you, Charlie, I might take that and say, I know it's important to you that I believe you're innocent, but it's not important to anybody else. Yeah. And so I try to, because they are time consuming and oftentimes, you're not getting, I'm not getting any of my money back on them. I got to make sure that they're good, solid cases for reversal. And oftentimes they're just looking for a new trial.
Yeah.
And they could get reconvicted, there's no promises there.
It's interesting. We talk about people who are so reluctant to accept the fact that an inmate was unfairly convicted, and then people think that a guy like you, Gonzo, or you, Charlie, just step in and magically get this person out of prison. But nobody has, you have to really be a lawyer to appreciate the volume of work that it takes to resurrect evidence that wasn't there years back, how to research the applicable case law, how to present that to the court, how to gather appropriate witnesses. It is a really steep mountain to climb.
Well, there's more to it too. You know, in our civil cases, oftentimes our client can match the opponent in money and resources, right?
Sure.
And when you don't happen, you try to get it settled because look, we can't go up against the biggest firms in Ohio based on your budget, right, client? But in these cases, a lot of times you have no choice. And I bet Charlie's firm spends thousands and tens of thousands of dollars. I know the last DNA expert that I had wanted 10 grand to do what we wanted her to do just to get a report. So I imagine it's pretty expensive, right, Charlie?
It's always expensive anytime you start doing that kind of testing, and not everybody can afford it. But and that's why, as you point out earlier, that it's very helpful to be with a large firm that has a lot of resources and is willing to commit those resources to support an innocence case. It's as we know, because you guys are involved. As I said, it takes a lot of effort and expense to work these things through the system and finally get relief. I think one of the most important things I tell all the people that work with me, I said, we've got to convince the judge that the person's innocent. If the judge does not believe the person's innocent, it'd be very difficult to get these cases overturned. So our first job is we want to do everything we can to convince the judge that we're before that the person is actually innocent. If you can do that, I think you got a great chance of getting this thing reversed.
I do have a lot of faith in our judges still. I think that, and I hate to say it as an older lawyer, because I remember the lawyers that were older than me when I was coming up through some of my firms would talk about how the practice has changed so much. But I start to see a lot more politicians being judges around our state. But when you go to some of these small communities, it's still the judge was the best lawyer in that community, and that's still pretty much the way it is. And so I like dealing with the judge that was also a really good lawyer.
Yeah.
Well, I imagine with what President Trump's doing, forcing these large firms to do pro bono work, we're going to see more firms representing
that's
criminals.
Pro bono work he's interested in.
I doubt it too. I really do. But I read somewhere, Charlie, that you are in your 80s and you're still doing this, which is amazing. Just looking at you, I would never have guessed that you're in your 80s. And I'm 63. Jack's a little bit older than me, and I think this is one area, this post-conviction stuff, that I'd like to carry on into my retirement because it's probably, of everything I've done, the most important. But I thank you for the inspiration.
Well, as I tell people, I think as long as you stay working mentally, it does help you continue to be young and continue to thrive and be healthy. I like what I'm doing. It's fun. I'm like you, John and Jack. I'm a civil lawyer primarily. This is sort of a side job, these innocence cases, but they're very rewarding. You get a lot of satisfaction of being able to overturn a conviction of somebody who is innocent.
Charlie, I am delighted that you accepted our invitation, and I say this as genuinely as I can. You're the type of man that makes Notre Dame proud, and I'm sure that I would imagine Father Hesburgh is listening to us now from a remote site, but I'm sure he's smiling and regarding you as one of Notre Dame's favorite sons, so good for you.
Well, thank you. As I said, it was an honor to attend the University of Notre Dame.
If you like what you've heard, Tell a friend we want this to be more than just us. We'll be back in another couple weeks with another important social justice issue. Until then, so long.